Hi everyone, I'm just recovering from COVID, so I'm just recording a few videos that I meant to do for about 8 months or something I haven't got around to yet. And the first of which is about data protection, but don't turn off yet because it's actually much more interesting than you might initially realise. Now, I've said elsewhere, data protection law is probably the quickest and kind of most effective way of holding homes for services to account, because essentially people using services can request a copy of their records and then essentially look through them to see what mistakes have been made and so on. So it's already a really good set of laws. But there's a lot of stuff which is kind of hidden away, which is really kind of it makes you think as a professional about what you're actually doing and what your purposes really are and what your aims really are. And I know a lot of, I'll give some examples of this in a minute, but I know a lot of services, in effect, they end up gossiping a lot about their clients. That's all it really is. And they'll call it, we're doing this because we're safeguarding the client or whatever. We've got, this is for the public interest or whatever. And so if you get it right, you will have a person-centered service, and you will probably be respecting the dignity of the individual in a way that services that get this wrong just simply can't. They can't even grasp it. So I'll give you an example that kind of this is based on, but this is happening all the time. So a few years ago in Bedford, there was this kind of rough sleeper multi-agency panel, which was, I think, about a dozen or so different agencies, and they met every 2 weeks and they would discuss about 25 different individuals. And I think this is something that happens, across the country, so it's not unusual in that sense. But crucially, there's a number of things which made it unlawful. And I'll try and go through some of them at least. So the first was that certainly some of the individuals had literally no knowledge at all that this was going on. So they were not invited to these meetings about them. They weren't even told that they were happening. And one of the partners in the meetings were the police, and I know certainly some of those individuals were really annoyed about that, the fact that their mental health data or their kind of substance use data or whatever was being shared with the police, because it really kind of called into question what it was really about. And just as an aside, obviously every charity will tell you how much they care and how much they promote the well-being of their clients. Data protection law and how it's used is a really good window into the soul of a charity. So something I'm just going to throw out there, really, because you can kind of get a good handle on how much they really care by how careful they are with that person's data. Because if you're homeless, if literally all your worldly belongings are in a rucksack, then actually, your data is probably the most valuable thing that you own. And then how agencies treat that, do they kind of send it off willy-nilly? Do they send it to the wrong person? Do they lose it? All of those kind of things will tell you a lot about how much respect they really have for the individual clients. Sorry, I digress. Going back to the kind of this multi-agency meeting. So the individuals, as far as we can tell, were not told this sharing was even happening. It was being shared with organisations that had no reasonable prospect of ever knowing them. So as an example, it wasn't the only example. So Bedford Prison was one of these partner agencies, which is a male-only prison. And yet female clients were being discussed in all of their most intimate details were being shared verbally and then in writing with Bedford Prison, who's got no good reason to know this stuff. So it was already in breach of the data minimisation principle. Now, we raised it, there's a number of things still ongoing with it, actually, but basically one of the defences the council said was that, oh no, it's okay, this is for the public interest, this is safeguarding clients, essentially this is professionals safeguarding clients, that's why we're doing all this stuff. Now, again, I don't know everything that was going on there. We were supporting 4 individuals who were discussed in those meetings. And in all 4 cases, the meetings had no effect or no positive effect on them getting housed at all. In 3 of the cases, it was our intervention that got the person housed, and in another, it was a different agencies that got the person housed. So although they were meeting up, every 2 weeks, it's really questionable how much or what they were really doing. Other than kind of sharing the data around, it doesn't appear they were taking even very basic steps to actually get someone housed. And we got complaints based on some of these things upheld and compensation paid out. So, as I say, there's still some outstanding issues with it. But this kind of thing of safeguarding crops up because this is also true for MARICs, by the way, so multi-agency risk assessment conferences around domestic abuse. Again, it seems it's fairly common for MARICs to basically not tell the individuals what's really going on with their data. They're not told who it's shared with. They're not told, what they can do about it. All those kind of basic data rights, it appears they're not actually being told. And just there's some kind of bigger picture stuff which you can ignore if this is all jargon to you. Certainly with the rough sleep and multi-agency panel, there was no data protection impact assessment ever done for it. And as far as I can tell with the Bedford Marrick, it's the same. They haven't done a DPIA unless they've done it very recently. So these are things which organisations should be putting in place to make it be safe and make it respect the individual. But they kind of get bulldozed by the wider or the kind of higher aims. High is probably a debatable word, but the aims of the organisation. And so I'm saying a lot here before we even really get into the meat of it. If you don't understand data protection law, a really good kind of way of gauging it is, if you were doing something with your client's data, and they were looking over your shoulder, would they be happy with what you're doing? So if you're just sending emails to random people almost, and kind of not password protecting it, I'd imagine most clients would be a bit pissed off by that. If you're sharing it with the police when you've got no reason to share it with the police, they'd probably be pissed off with it. So that's a good kind of litmus test for whether you're following the law, because the law is really just trying to get at that, it's basically trying to stop organizations using data in a way which the clients would be objecting to. And it's probably more important as ever in the homeless sector, where people who've been homeless are so powerless in the system, and effectively homeless organizations have so much power over them. So it's a real kind of check about that. Anyway, let's get to what we're actually here to talk about today. And I'm going to be picking apart this kind of this myth out there that safeguarding enables you to do whatever the hell you want with your client's data, because that does seem to be how it's often used. So I'm going to be looking at that safeguarding condition. And in fact, if I just share my screen, it should hopefully work. So here we go. Right. So this is Schedule 1 of the Data Protection Act. It's Part 2 of that schedule. And we're looking here at paragraph 18. So if you Google Schedule 1 of the Data Protection Act, you will get this. This will come up as a PDF. And within that, so this is kind of part 2 is talking about substantial public interest. So again, you hear organizations saying, oh, it's in the public interest, it's okay. Well, that's what they're trying to talk about here. They're trying to say substantial public interest, and they're trying to pin it down to one of these subcategories. And there's loads, I think there's like 23 subcategories, some of which could never ever refer to the situations we're dealing with. So for example, there's like anti-doping, things like that in sport, which is not relevant. But the safeguarding of children and individuals at risk is most probably what they're trying to say, even though they probably never read this. So, but there's some really important criteria here that are almost certainly not being met when this basis is being used as a basis to share information. So, right, so, and I'll just go through it basically as a quickest way of doing it. So, paragraph 18, this condition is met if, so A, you're protecting the individual from neglect or physical, mental or emotional harm, so I don't know why it's not using the word abuse there, but that's what we're talking about. So that's the first thing, and I could talk more about that, but I'm going to try and keep it simple. The next two are the key things. So we don't have to be, so, and bear in mind, it has to be, all of these have to be satisfied for it to be legal. So B, the individual is either aged under 18, so a child, or aged over 18 and at risk. And that at risk thing is crucial. And for me not to kind of get lost in the complexity of how this is set out, I'm immediately going to just scan down here to subsection 3. So for the purposes of this paragraph, an individual aged 18 or over is at risk if the controller has reasonable cause to suspect that the individual, A, has needs for care and support. I'll say more about this in a minute. B, is experiencing or is at risk of experiencing neglect, physical, mental, emotional harm. And C, as a result of those needs, so as a result of those care and support needs, is unable to protect himself or herself against the neglect or harm or the risk of it. Now, for those who've worked in the sector for a long time, should probably recognise this, because this is almost the same wording, or certainly the same concept as Section 42 of the Care Act, which is all about safeguarding. So in the training we do around the country, we get a lot of professionals saying to us, we don't bother making safeguarding alerts anymore because nothing ever happens with them. And the first thing to say about that is, don't be stupid. You need to follow the policies and raise safeguarding alerts. But it's important to understand why those safeguarding alerts don't seem to go anywhere, because it's not that they're not going anywhere, it's just because they don't hit certain criteria. And it all comes down to this third one, C. So when you make a safeguarding alert to a council and it comes back and saying there's no further action, they're not saying the person isn't at risk of abuse, and they're not saying the person doesn't have care and support needs. What they're probably saying is the person is basically able to protect themselves. So their care and support needs are not stopping them from protecting themselves. So that's the key thing. I probably haven't explained that very well. One of the case studies we do in the training, is anonymized, but basically it's a lady who had very significant mobility issues. She was subject to domestic abuse, and because of her mobility issues, which were care and support needs, she was not able to flee the property. So she was not able to get away from the abuse that was happening. And that is why, in that case, it met those 3 criteria, and she was supported by social services in that case. So that's hopefully kind of reasonably useful. So that's kind of what it's talking about. So it's not just about any adult, and it's not even like a kind of a, you know, any adult at risk. It means something very, very specific here. So unless these 3 criteria are met, you can't use safeguarding as a basis to process special category data. So that's the first thing, and it gets even more difficult, which I'll show in a minute. So again, let's just reiterate this because it's quite confusing. So processing is legal if A, you're protecting someone from harm, B, the individual hits those 3 criteria, the most crucial being they're unable to protect themselves as a result of the care and support needs. And then it gets on to C here, which is the processing is carried, and this is the most important one, the processing is carried out without the consent of the data subject for one of the reasons listed in subparagraph 2. So we're going to go down to subparagraph 2. I don't know why it's set out in this order, but it is. So the reasons mentioned in subparagraph 1C. So just go, it's a maze, but anyway. So there's 3 things. Again, there's 3 criteria. You have to, in this case, you only have to meet one of them. You don't have to meet all 3. So in the circumstances, consent to the processing cannot be given by the data subject. So again, let's just reiterate what this is saying. So you can only use safeguarding as a basis to process data if A, they hit the kind of the 3-part criteria, and B, they cannot give their consent. So the idea is that you ordinarily, your primary reason to process special category data is the person's consent. That means informed, it means granular, it means freely given, all of those kind of things. So as a charity, that is going to be something which underpins everything you do, basically. So consent, so in this case, you can only use safeguarding if consent to the processing cannot be given by the data subject. So that's because they're unconscious, or that's because maybe they don't have mental capacity at that point. So and again, I'm not going to go off on a tangent there, but anyone can assess mental capacity. You would presume that someone has capacity unless you've got a reason to think otherwise. And there's basically a 4-part test that anyone can do, where you're basically assessing their capacity at a particular moment in time to make a particular decision. There's more to it than that. There's a whole load more to it than that, but that's kind of ballpark what we're talking about. So again, you can't use safeguarding unless consent cannot be given because they lack capacity or they're unconscious. Or B, the controller cannot reasonably be expected to obtain the consent of the data subject to the processing. And again, I'm not even quite sure what kind of situation this would apply to. My best guess is that, say you're working with someone, someone runs into the office, hey, Joe Bloggs is being beaten up down the street, they're really hurt, or they were beaten up in the street earlier, they look really, in a bad way. In that situation, you will probably want to ring an ambulance, or you probably want to do something with that information, but you can't find them, so you can't you can't obtain their consent at that point. That's, I think, what it's talking about here. But that will not apply to 99.9% of your clients, because you've had plenty of time, or you should have, to talk them through what consent means, talk them through what they're even consenting to, and obtain their consent. So again, that's something that's unlikely to apply here. And then C, the processing must be carried out without the consent of the data subject, because obtaining the consent of the data subject would prejudice the provision of the protection. So again, this is a really weird and wacky one. It's very unlikely this will apply. I think it's talking about situations where, let's say, you're concerned that if the person knows you've just rung an ambulance for them, that they'll run off and they'll be at risk of more harm. So in that situation, which is a very specific situation, you could say, well, okay, we're not going to ask for their consent, because if we ask them if it's okay to speak to an ambulance, we're afraid they're going to run and go and harm themselves. So we're just basically going to ring the ambulance and hope they just kind of turn up and manage the situation as it arises. So again, that's not going to be relevant to 99.9% of the situations. What this is essentially pointing to is that consent is your basis for doing pretty much everything. You know, if you are a charity, unless you are reporting someone to the police for fraud or like other criminal activity, it's going to need to be done on their consent, which is why I say at the beginning, you know, if you imagine that client looking over your shoulder and seeing what you're doing with their data, and if they're likely to object to it, then you're probably outside of those kind of remits. And just to kind of clarify, you do need to ask for the consent, not just think what they might hypothetically do. You do need to specifically set down what they are happy with you doing. So that's hopefully helpful. As I say, it seems really, really niche and obscure, but in my opinion, as I said already, data protection law, if it's followed, is a really good way of making you think, okay, I need to actually respect the individuality of the clients I'm supporting, and not think that I am somehow privileged enough to make decisions about them without them being involved in it. And going back to this kind of rough sleeping multi-agency panel in Bedford, the idea that we were going to, I wasn't part of it, but they were going to achieve anything useful when the individual themselves were not even invited to those meetings, or in some cases at least told they're even happening, is really kind of just, questions what the hell the homeless sector was really thinking they were going to achieve by doing that. Because it's no good, your support worker turning up and saying, right, you didn't know about it, but we had a meeting last week, the police were there, and we've decided that hostel A is going to be best for you. And unless you accept it, we're going to say that you're being uncooperative. That's a really, really shitty way of doing anything. It's data protection law does not stop you having that multi-agency working, but what it does, and what it really kind of forces you into, is saying, okay, rather than having a conveyor belt meeting where we discuss lots of different people, we're going to speak to Joe Bloggs and say to Joe Bloggs, would you like us to have a meeting with your supporting professionals with you, so we can discuss what it is we can do, what it is you want, so we can try and make a bit of a plan forward. And so, and ultimately, that's the ideal. You have tailored, bespoke support meetings with the relevant professionals, certainly no one who's not relevant, crucially with the person there, so they can say, well, actually, I really hate hostel A, and no chance in hell I'm ever going to go there. Let me tell you what I actually want, so you can start, providing a service and helping me out with that. So, yeah, again, hopefully that's helpful. You'll notice with YouTube, we've started kind of jazzing it up a little bit and trying to increase our reach. So far, it's quite interesting how little effort it takes to get it out there. But basically, if you find this stuff useful, please do like the video, please do subscribe. And if you ask any questions around data protection law on this video, I will happily answer them, and happy to go into a lot of detail if necessary. What I can't do is kind of take on individual cases through YouTube, but I will try and give some information which is helpful for you. So yeah, hopefully that's helpful. Take care.